Well, why don't we get going? Good morning. I'm John Casper of the Oshkosh Chamber, and welcome to our monthly HR briefing with Von Briesen and Roper. And with us today is, as always, Jim Macy and Jonathan Iden. Thank you all for joining us again. We're recording today's session, and this session is part two of what we started last month with state and federal legislative updates. And I was just saying before, I was in Florida at the time and missed the first one. So, but Jim said it was a great program, and our legislators were very informative. And so now we're going to get down to some of the meat of legislation that's being bantered around in Washington and the state. So with that. We have the Q&A tab on the bottom, and as people ask questions, I think John and Jim will be monitoring those, and we'll answer those as they go along. So with that, I will throw it over to Jim, and Jim can take it from there.
Well, good morning, John, and thank you very much, and good morning, everybody. And as noted, John Iden is joining me again this morning. We're doing part two. This is the annual part we always do in terms of tell you a little bit about some of the case law that's going on and things you should know, some of the legislative developments that you should know. And we talk more about the statutes and the regulation and from a practical standpoint of what helps you within your companies, a little bit different than what we had received from the elected officials the last week. So as John said, any Q&A, feel free to just join in with that, and we'll start right through this stuff. So we first talk about maybe some of the court cases of interest and things that are going on with that. Just a couple of quick things in regards to that. And they have to do with what's going on with discrimination cases. There's been a debate amongst the different parts of the country as to what's the standard of proof and what's the test. And what these cases were telling us from a lawyer's standpoint, but it's important from your standpoint too. It's a little different than the state. But as you know, under the state law, if any part of a decision is discriminatory, we've got a problem. But from a federal level, the burden is a little tougher. It's called the but-for test. And in other words, but for some discussion of discrimination or some aspect of discrimination, if the event would have happened anyway, that somebody would be terminated, that's going to be upheld under the federal law aspects. Later, we're going to talk about even a little more why this is important, because even though we said under state law it's a little tougher test, the federal government is starting to pick up cases that the state did not before, or even where the state did, they're coming in to reinvestigate after the state already did its thing. And I'll talk about that a little bit.
The other federal case of significance, and this is an issue or, like I said, an issue and a decision that we've had years ago when the Affordable Care Act mandated certain preventative care, including contraception for female employees. And there was a moral and religious objection. And the Hobby Lobby case was the one that most people are probably familiar with. And as I said, I think that was back in the 2014, 2015 time period. And it upheld a private employer's right to not provide contraception if they had a legitimately held religious belief. And this is the latest iteration of that line of cases. And in Little Sister of the Poor versus Pennsylvania, this dealt with particularly the interim final rules that were passed, and I believe it was 2017 by the Trump administration. What it had existed prior under the House of Worship exception for the contraception providing required that the religious organization or the private employer self-certify the nature of the religious belief that would be grounds for the exception and the reason why they did not want to provide. Now, the religious entities and those who had the religious beliefs objected to the requirement that they self-certify. They didn't want to participate in the process at all. They argued that it infringed on their religious freedom for having to certify. So the interim final rule had indicated that they didn't have to self-certify, that the exception allowed them to not provide the contraception, again, without the self-certifying requirement. That the details of the case is largely procedural. The arguments were that the proper rules weren't followed, and implementing these rules, that authority was beyond the scope of what was authorized. The Supreme Court rejected those arguments, so it didn't change the religious exception. The interim final rule, which expanded the religious exception, is still maintains. What was really noteworthy from this case, at least in the eyes of the people who closely evaluate Supreme Court decisions and watch for shifts in how they analyze these issues as the court evolves and becomes more conservative or liberal, depending on who's appointing the judges. That's really the granular level that this case was analyzed. And what was noteworthy to those individuals is that, unlike in Hobby Lobby, where there was a significant amount of discussion regarding the potential impact this would have on employees and third parties not currently involved, but what is the impact of our decision type discussion, that wasn't present in this case. And the Supreme Court focused strictly on the statutory authority under the law and the procedure that was followed, without, again, a discussion of the impact of the decision. And depending on where you come down on this issue, you would say, well, that sounds like the scope of their decision-making authority in this case, and the Supreme Court stayed within their arena. They're not supposed to be legislators. They're not supposed to opine or issue decisions based on the overall impact. That's what the legislative branch is for. And obviously, if you disagree with this line of cases that exempt certain individuals, you would be frustrated with the fact that the Supreme Court didn't wade into those waters. But that was really, again, the topic of discussion from a legal standpoint, and the exception under the ACA. That law remains the same and has not changed as a result of this case.
You know, and John, as we talk about that and as we go to the next slide, it'll be interesting under the new administration with the further discussions about healthcare and the anticipation that we're going to see more challenges, whether things come through executive order or whether they come through legislation. So stay tuned, everybody. And of course, we'll update you as those developments occur. Just briefly, because I know people are pretty much familiar, but there's still questions that we're receiving under the rescue plan of 2021. If I was trying to keep track of mega bills, this is one of the quick ones into the new start of things. And the first issue we really were concerned about, we just weren't sure, actually, even when they passed it, what they did with it. It took quite a bit of digging and working with the legislative offices themselves. But it all settled out fairly quickly that although the law extended those 2 leaves, and I'm talking about the couple weeks of paid leave as leave 1, and then the extended FMLA leave, that they did offer at least the opportunity, let's say that, to extend it. And the difference we were trying to find out was, were they going to mandate it? And if they mandated it, how is that going to play into the fact that we were already into the new year and the other aspects where it had expired at the end of the year? So what we did know, and what you know, is that they expanded it and they're no longer mandated. It's still allowed for the tax credits, but it did make some modifications to it. So the way that worked was, you did not have to extend either the paid leave or the FMLA. But if you did, you would get tax credits, and then there would be some exceptions. So the reasons for the extended leave continued with the original 6 as far as that goes, but then it added issues that people could be off for those 2 weeks related to the vaccine or relating to getting a COVID test. So what kind of issues are we seeing over that? Well, we're seeing issues about verification that somebody actually is getting a vaccine or in process of that, or issues getting a COVID test instead of, I just came in contact with somebody, which still may relate back to some of the prior of the 6 reasons for leave, but still some of the same verification issues of those that actually have an issue and may be quarantining, whether or not there's actual medical verification of the needs for some of these aspects of things. So some of the same typical kind of verification issues are arising under that aspect of things. The second aspect is it resets the 10-day bank. So people get that extra 10 days if they've already used it, but 10 is still the max as far as that goes. You didn't get to, if you used 2 and had 8 left, you didn't get 18 into the new year. It didn't bank into that aspects of things. So then there's the second group of leave, the extended FMLA, and the tax credit aspects of that again, allow for the childcare aspects and the school closures as it did before, but it also now incorporated any of the other reasons that were available from the other paid leave. That's pretty significant, okay? So now you've just taken what might have been 2 weeks and raised that up to as much as 12 weeks if it falls under all of these reasons, although there still are aggregate caps that come into play as to how much money somebody can get from that. Practically what's happening, I got a call yesterday and they said, Jim, well, what are people actually, what are you seeing from businesses in terms of what did they decide to do on extending these leaves or not? And it really varies depending on the culture and your company and the other aspects of that. I think as an overall, John, you know, and you and I have talked about this a lot, but in terms of what we see, and is that some are adding the 2 weeks leave, but they're doing it as a local policy to some extent. And they're not necessarily adding the FMLA because it's so expansive and it's just too much time off at a time that, you know, when we get into this area, into Winnebago County and this part of the state, and that's fun to talk to our colleagues, by the way, in other parts of the state. But when we're rolling along in the 3% of unemployment numbers, with full employment being at about 5%, we're sitting pretty good, not only in terms of other parts of the state, but other parts of the country. So having the extended leaves and the other stuff, the reasons those leaves came into play was when we were on mandatory shutdowns. People couldn't go to work. We had to help people as far as that goes. Those same policy decisions don't exist anymore. Now we're open. Now we're begging people to get back. And some of the aspects of this, the same purposes don't fit anymore. So that's part of what I'm seeing. And John, you know, and I don't know if you got any other comment on that, but I think overall that's pretty much what we're seeing with that.
Yeah, I'm seeing the same, that employers who are willing to be flexible with respect to attendance policies, whether it's for vaccine or school closure or sickness. I mean, I don't think anyone, at least the employers that we're working with, they don't want people to lose their jobs over this. They also don't want to be locked into a mandatory bank of leave that provides an opportunity for a small group of people, what Jim and I are always dealing with, the small group of people who are abusing privileges and opportunities. And I think at the end of 2020, some employers had experienced challenges administering the FFCRA and those leave banks for those reasons. So again, they're flexible, they're providing benefits and giving employees opportunities to have time away from work when needed, but most aren't undertaking the adoption of the full policy, which comes with, I mean, you have some selection and discretion, but once you agree to provide this leave for these reasons, for purposes of tax credit, it's much more restrictive than within the employer's discretion. And just a final note on this topic, if you did have FFCRA policies, and I know Jim and I presented on this and kind of recommended, provided draft language. A lot of employers had some version of a policy putting employees on notice. If there is any concern that the employees are under the impression that that still applies, or that you've extended it, or drafts it, or versions of it are floating around and they don't have a clear expiration date on them, you're going to want to make sure that you clarify that the old policy doesn't apply and that the leave is no longer available. Again, if the policy is clear on its face, then no additional steps may be needed. But because this is still being reported on and it is at current legislation, there could be some confusion among employees, and you want to make sure that they're aware of what exists and what doesn't.
Then the other point that goes with that is you're deciding whether to apply it or not. If you apply the leave, and you're saying we're adopting the federal law, you're going to adopt their federal interpretation through the agency as well as that. And, it hasn't been as aggressive as we thought it might be in terms of that issue. But we still don't know as to where that's all going to go as this plays through. But just a heads up on that. And I think we got maybe one more slide on this, John. I think. Yeah, oh yeah. Well, and that's, again, the policies as to what fits or doesn't fit. And again, when we're trying to get people back to work, as John said, all employers want to help their employees. And if we don't have work and we can't help people, obviously we're not, offended by somebody getting unemployment compensation. I got to tell you, where all the debates are over this is where we're trying to get people back to work and they won't come back to work. So we've got the cases that have gone to hearing and gone through the process where they've said, well, I'm nervous to come back. I'm not going to come back yet. And we said, we got to have you back. And no, the other leaves don't apply. And UC has upheld the case to say if they've got work available and you don't come back, that's a resignation. So yeah, we've seen those kind of cases. The discipline cases are frustrating, very frustrating, where it could be misconduct or substantial fault type cases. And you have pretty good facts with that. And the people that are saying, well, gee, I can get rewarded by being a poor employee. Well, that's not a good policy in the state. And I'm just saying from a practical standpoint, and maybe from a little tainted point of view and working with all of you and working with employers and trying to get people back to work and trying to enforce your rules, it's really frustrating to see people rewarded that almost want to be out of work, don't want to work, and engage in bad behavior sometimes because I want to get UC. That's not good. So what are we seeing in the hearings as far as that goes? What we're seeing is the judges are definitely leaning toward giving benefits. Now, there's not a real new or novel statement. I mean, in terms of the policy of unemployment comp, and that's okay. We know that. And the burden, now I'm seeing more of the old language. The burden is on the employer, and that's okay. We'll accept that in the hearings and the other aspects of things. But to step through some of the, more often than not, substantial fault kind of cases where you've done all the right paperwork, you've done all the right policies, you've done all the right stuff, and they still say, well, they were working to the best of their ability, et cetera, is a little frustrating. So some of those cases are going up to the Labor and Review Commission, and all due respects, the Review Commission has overturned some of their judges where you have a good record and a good paper trail and good policies. So what you put together for that UC case is really important. Here's another pointer on your UC cases. Make sure you respond to their investigatory questions during the initial determination point of this. They are unbelievably overwhelmed right now, and their timing is poor. So you won't get that call or that request right away. But when you do, they give you all of a day or two to get back to them with everything in the world. And if you don't, they put in the decision that the employer didn't respond. So if the initial determination gets overturned, for example, they don't give benefits, and then they do later, or vice versa. Somebody got benefits, I'm sorry, that's the always gets benefits, and it's overturned. The employee won't have to pay it back because the employer didn't respond in a timely manner. Unbelievable. But just a pointer, a heads up, stay with those timelines in response so that's not on you as far as that goes, and then, on your account later. Then when you're in the hearings for another seminar, but just a quick pointer on this, make a really good record. Make sure your policies are in there. Make sure the times that you talk to the person are in there. Make sure you have your witnesses available. These are all phone conferences, so you can all be in a conference room and respond to the judges as far as that goes. And don't be frustrated when you do all of that, that they go, well, but just have a good record. So if you want to file a letter, it's not expensive to appeal. The record is based on what happened at the UC hearing before the administrative law judge. There's no new evidence. There's no new costs with any of that. Make a good record. Why is all of this happening? State's overwhelmed, first of all. There will be audits, and we'll be reading about problems of this for years down the road in terms of what really happened at the state. That's for another day. But there is so much money coming into the system from the federal government that the state is an agency. My humble opinion on this is there's so much money coming into the state, they have no incentive but to give everybody money and not deny people. And it's just wrong from a state standpoint and other purposes, but that's what we're dealing with. Make a good record. We'll look at it at alert level and we'll go from there. And as John said earlier, we're talking about a minority of people. Most of the people are great. Most of the people want to work. Most of them do a great job. But for our usual suspects, that's the game plan for dealing with the frustration of use right now.
So the next couple slides, I'm going to try best I can to distill the Cobra subsidy period and the notice requirements down to a couple slides. At the end, I'll make a pitch for a program that we're doing. It's an hour just on this issue. So if you're overwhelmed, lost, confused, there's an opportunity there for additional information. But under the American Rescue Plan Act, there is a period of subsidized Cobra, meaning free Cobra for the employees. The employer pays the premiums and then they're reimbursed for amounts equal to the premiums paid through payroll tax credits. And the subsidy period is from April 1st, 2021 through September 30th, 2021. And it basically provides any employee who had a qualifying event during the subsidy period or within 18 months prior to the subsidy period, they need to receive notice of this subsidy period and be given an opportunity to elect Cobra coverage. And what they can elect, the opportunity to select a different plan. There's details and nuance to the actual administration, again, for the more detailed program. But for purposes of this presentation, it's important to understand the subsidy period is from April 1st through September 30th of this year. And eligible employees will be those who've had a qualifying event that is either a reduction in hours or an involuntary termination after November 1st, 2019. So again, from today going forward, if an employee has a reduction in hours or an involuntary termination, and they're receiving their Cobra election notice, which is routinely sent out whenever an employee separates and loses coverage under the plan, your current Cobra election notice needs to be updated to include information about the subsidy that is set to run through September 30th of this year. So an employee, once they have a qualifying event, they are eligible for 18 months of Cobra coverage. Once they receive the election notice, they have 60 days to either elect or decline Cobra coverage. So going forward, that procedure and that timeline stays the same, with the only caveat or the only change being the content of the notice. And the DOL has released updated draft notices that include the required information regarding the subsidy period. Now, if an individual is involuntarily terminated on May 1st, elects to have Cobra coverage, subsidized Cobra coverage under the American Rescue Plan Act, that'll run through September 30th. After September 30th, the employee then will be responsible for paying Cobra coverage paying premiums for Cobra going forward. The subsidy ends as of September 30th, or if the employee becomes eligible for Medicare or coverage under another health plan. Their spouse gets a job where they're healthcare eligible, the employee themselves gets another job where they're healthcare eligible, and the law requires that the individual notify the former employer when they become eligible, again, for benefits either under a new employment plan or through Medicare. The look back, so the going forward piece isn't really that complicated, with the exception of updating your notice. The look back period is new because the subsidy is available for individuals who still have Cobra eligibility, meaning they've been reduced in hours or involuntarily terminated within the last 18 months. So their Cobra clock is, or their Cobra period, they're still within their Cobra period. Now, these individuals may have not elected Cobra or elected Cobra for a period of time and haven't been paying premiums, some for several months, but they still have to receive a notice of this new expanded opportunity for election. They need to get an updated notice regarding the subsidy, and again, their opportunity to elect the subsidy. And then once they receive the updated notice, again, they have a 60-day time period to elect the subsidized coverage. So if you have someone within the last 18 months who's still within that Cobra period, they also need to receive the notice by May 31st, 2021. So this slide touches on the notice requirements. Again, the updated notice for any eligible employees with a qualifying event going forward, and then the notice to any individual with a qualifying event after November 1st, 2019. They have to receive that notice by May 31st, 2021, and employers can face penalties and fines if they do not provide the requisite notices. The other important piece of this, when we talk about individuals who are eligible for the Cobra subsidy, it's only for qualifying events based on reduction in hours or involuntary termination. It is not eligible, or it's not available for individuals who lost coverage because of their voluntary resignation, or if they lost coverage due to a life event. So you're an individual on a family plan and you divorced the spouse who had coverage. The spouse who had coverage passed away. You were dependent on a plan and you lost coverage because you aged out of the dependent category. None of those qualifying events under the Cobra law would entitle the individual or allow the individual to take advantage of the subsidy. It's only limited to reduction in hours and involuntary termination. And if this wasn't complicated enough, that the 60-day timeline for election is still in place with regard to the Cobra subsidy. So if someone receives their Cobra election notice, they have 60 days to elect Cobra coverage. If they do not elect within 60 days, they are ineligible for the Cobra subsidy. However, earlier this year, under the Employee Benefits Security Administration, this bill suspended a number of federal timelines, including the Cobra timeline, the 60-day Cobra timeline to elect coverage. So right now, most employees are operating, or the primary focus is on the Cobra subsidy, which again still has that 60-day timeline. But there can be a circumstance, and I just bring this from an issue spotting perspective, there can be a circumstance where an individual is involuntarily terminated on May 1st. They receive their election, their updated election notice. They have 60 days to elect Cobra coverage. They don't elect Cobra coverage within 60 days, so they are not eligible for the Cobra subsidy. Under the EBSA, the individual still has time to elect Cobra coverage that they themselves would then pay for. So be careful when you're administering and dealing with these deadlines to be mindful of the distinction between the 60-day deadline that's still in place under the Cobra subsidy and can absolutely be enforced with regard to the free Cobra, but don't be so quick to deny an election altogether if they don't meet that 60-day deadline, because under the EBSA, the employee may still be able to elect Cobra outside of that 60 days. They would just have to pay for it under traditional Cobra. So trying to distill this down to a one-slide summary on action items and next steps. Identify all individuals with a qualifying event after November 1st, 2019. And again, that qualifying event must be a reduction in hours or an involuntary termination that has resulted in a loss of coverage under the plan. Provide the notice of the extended election period and subsidy to those who had a qualifying event prior to April 1st by the deadline, which is May 31st. And then going forward, update your Cobra election notice to include reference and discussion of the subsidy that's available from April 1st through September 30th, 2021. And again, I believe it's next Tuesday, the firm is doing a program focused specifically on Cobra updates and this topic, the APRA and the updated deadlines and notice requirements. Feel free to reach out to Jim or I, and if you're not on the email list already, we're happy to provide that information if you want to take a deeper dive into this issue. The next piece I want to talk about, next piece of federal legislation is the PRO Act. This was introduced by House and Senate Democrats on February 4th. It's supported by President Joe Biden. And again, this deals with the National Labor Relations Act, employees' right to engage in protected concerted activity, commonly known as kind of organizing activity and union activity. And this is an issue now in 2021 where you are in an industry where organization efforts are common. You have competitors, or you've dealt with organizing efforts, or you haven't dealt with a union or an organizing effort in your entire career, and you likely won't. It is now at this time, it was much broader and involved a lot more or encompassed a lot more of our practice than it does now. So I'm only approaching this. I say that because this isn't going to be a deep dive into the PRO Act and everything that it includes, but it's an issue spotting, one, to identify and kind of lay out what the administration, the new president's administration's viewpoints are on organizing activity and what they're intending to do during his term as president. And then also kind of give you, again, a high-level overview of the changes under the current National Labor Relations Act, the interpretations and the rights that and the laws that govern how employers and union organizations conduct elections, negotiate contracts, the rights during strikes and boycotts. It's really a broad sweeping proposal that would impact every aspect of that relationship. Yeah, Jim.
Yeah, John, before you just get into that, let me just point out a couple of things. If you're on this call and you're going, well, we're not union, this isn't going to apply to us, you're wrong. This is exactly why this impact is for those that are not unionized right now, but could unknowingly and very quickly face it, because these rules make it easy to organize your workforce and you become union. 10.8% of the workforce in the United States is organized. And we would say, gosh, that's not much at all. Politically, what happened with this is the union certainly supported President Obama back when he first ran. And payback was to do this law. And they were really ticked that Obama did not bring it up early. He went with the insurance issues and other things first and never got back to this. And they were really ticked. So the trade-off this time around was, we'll support you, but this time you guys better step up because we didn't forget that you forgot about us last time. This is past Congress. This is not past the Senate, but it's one Senate away, a vote in the Senate away as to whether this comes into play. It's a big deal if it goes for you that are non-union.
And just to further emphasize that point, President Biden has tweeted, because that's how presidents communicate now, the policy of our government is to encourage union organizing, and he's pledged to be the most pro-union president in history. So, I mean, from Jim and I's perspective, watching the changes in the presidency, which then has a change in the National Labor Relations Board appointment, and the political component of the National Labor Relations Act, and how the administration of that law and an interpretation of that law has shifted. But in the last decade or even longer, the moves have been, the pendulum has swung relatively small. And this now changes the game significantly. And also, more importantly, you have the executive branch coming out strongly in favor of one side of the equation, on the pro-organizing side of the equation. So to Jim's point, it does ease, it does make it easier to organize. It makes it easier to get a contract, and makes It gives the union more tools at their disposal when in a relationship with an employer to put leverage and pressure on them. We'll talk about some of those specifically here. One of the biggest changes, because Wisconsin is a right to work state, which the right to work law indicates that an employer, employees cannot be compelled to join or pay union dues as a condition of employment. So a lot of unions historically have had a closed shop provision, meaning if you work here and you're in a job description that's in our collective bargaining unit, you have to be a member of the union and you at least have to pay your fair share of the dues for all the efforts and the representation that the union provides you. The National Labor Relations Act currently does not prohibit states from passing right to work laws, which make it illegal essentially to have a closed shop provision in the collective bargaining agreement. The PRO Act would change that law so that I think it's roughly 27 states that currently have right to work laws. Those would be repealed essentially, or more specifically, more accurately, the federal law would trump the state law, so the state laws would not be enforceable. The PRO Act would make secondary boycotts acceptable. You're in a dispute with the primary employer. They have a key they have a key supplier. They have a key customer. The secondary boycott historically has been prohibited, meaning the union cannot go to these other businesses that are conducting business with the primary employer and picket or handbill those organizations. The focus, the picket, the efforts have to be limited to the employer that's in the dispute. That would change and allow the unions to provide or to conduct secondary strikes and boycotts.
John, let me just add a couple examples of that. And why does it matter to a lot of us around here? If Oshkosh Corporation, which is unionized by the UAW, goes on strike, all the suppliers of all of the parts and everything related to Oshkosh Corporation would then become subject to a strike at your facility, even as a non-union employer. I can't tell you how many suppliers and how many of our companies are related to like Oshkosh Corp or some of our other corporations and others that are unionized. This is huge. This was never even remotely on the screen to impact all these other businesses who then got to decide, now what do we do? Do we play with Oshkosh Corp or who's ever getting a strike, or how's that going to impact us? So you don't have to be organized to have a huge impact. It's a big deal.
Some of the other changes in the PRO Act, striking employees could no longer be replaced as it is under current law. A union goes out on an economic strike over a breakdown in negotiations over the collective bargaining agreement. The union goes out on strike, but risks the permanent replacement and the lockout of those individuals. Right now, an employer that's dealing with a strike can hire replacement workers and tell those individuals on strike that they're not allowed in the facility and aren't coming back to work as a result of their strike activity. This would prohibit the permanent replacement of striking employees. So again, it's a fundamental shift in the leverage. Right now, the union says we're going to take all of our people and we're going to walk out the door. We dare you to try and find 100 new employees overnight. Your business is going to be shut down for weeks. And that's the back and forth. That's the leverage. Now, the employers are even more hamstrung in that situation without the ability to say, we'll find people and you'll be out of a job, or we'll lock you out and we're going to continue running this business. We don't need you. That dynamic, that piece of the negotiation is fundamentally shifted by this change in the law. The other piece is narrows the definition of independent contractor and supervisor. So right now, the Section 7 rights to engage in protected concerted activity, to organize, is limited to employees of an employer. And that has a specific definition, but excluded from the definition of employer are those who meet the requirements of independent contractor and those who are supervisors. So the new law would tighten the definition of independent contractor and supervisor, meaning there are less of those categories of individuals, more people falling under the category and the definition of employee. So people who were previously shift supervisors and excluded from a union and couldn't vote and were basically on the management side of the equation are now going to be determined to be employees and eligible for votes. And the same is true for independent contractors. There's a potential that depending on the independent contractor relationship, they may be deemed employees under the National Labor Relations Act, voting in elections, being subject to collective bargaining agreements, again, broadening the scope and authority and reach of the union, as indicated by Biden's message, that's kind of the purpose and the point. And then another significant shift, that these are all really fundamental and significant to Jim's point, but the other significant shift provides for interest arbitration in the first contract. So this doesn't exist in the private sector as of right now. The parties have to reach, as of right now, when there's a newly elected union representative, they go in and they negotiate a contract. And sometimes the first contract, particularly the first contract, where there isn't anything to work off of, can take a very long time, and rightfully so. They are now coming in and trying to memorialize all terms and conditions of employment into a document that's going to govern the day-to-day operation. And this is a time-consuming process. And under the PRO Act, there are now very strict timelines, very tight timelines. I think it's 15 days to provide notice. I mean, under 2 months to negotiate. If you don't reach a first contract within that time period, it goes to an arbitration where a third party comes in and decides what the contract is going to look like. So the employers are losing a significant amount of control over the negotiation of this first contract. You can go from election to arbitrator appointed contract within under a 6 month time period. I mean, that is a significant change in how things are typically done under the current interpretation and application of the National Labor Relations Act. Yes.
Sorry about that. I'm having trouble unmuting it, but just a quick point on interest arbitration. Wisconsin's been an interest arbitration state for public sector employees going back for a while. And you may recall our teachers, if they didn't settle, could go to interest arb. Our police and fire still can. I've probably done more interest arbitration cases in the public sector than any of at least the active attorneys in the state right now on the day that we were doing them. Act 10 changed all that because Wisconsin walked away from interest arbitration as a good way of settling those kind of things in almost all areas except police and fire, some transit workers. It didn't work, quite frankly. And boy, when we put this in the private sector under a quick, fast track, what happens is we delegate to third-party interest arbitrators your conditions within your contracts. There's no incentive not to go to interest arbitration as far as that goes. And that was the history in the state. We rejected it as a policy, and now the federal government wants to pick it up as a good policy. Again, it's another one of those things that if it happens, it's kind of a big deal. So we'll stay tuned.
Just to try and get to, the changes are broad sweeping and significant. The other change the PRO Act would invalidate mandatory arbitration agreements. There was a decision a couple of years ago, Epic Systems, where an employee agreement included a provision that said any disputes related to your employment has to go to arbitration, and also prohibited employees from joining together and pursuing employment disputes as a class action, and require that each individual employee bring their individual complaint through arbitration. The impact of Epic Systems back then, it was thought to be a fundamental shift in how employee disputes were litigated and the venue in which they were. It gave the employer essentially the opportunity to keep things out of the court and force them into arbitration. It didn't have the profound impact that I think a lot of people thought it would. But again, this is a change in eliminating the ability to even put those mandatory arbitration agreements into an employment agreement. It would provide the right to use, it would broaden the union's ability to use employer email systems for union communication and organizing activity. Now your hardware and your software that you're providing to your employees can be utilized by your employees to organize at your facility. And it would also bring back the quickie election process. It It was an election process that was implemented under the Obama administration and then taken away under the Trump administration. And I think, and now the quickie election would be back, which again is a fast track to, in organizing efforts, momentum is the key to success for the union. They're having meetings, they're getting people excited, they're getting people energized. They need to get from their rally call meeting where they have everyone in agreement to the voting booth and the election and the ratification of a contract as quickly as possible. Because the more information that is discussed and the more input that the employer has between that meeting and the time that they cast their ballot, that's to the union's detriment. So shortening this time period, shortening the election process, shortening the challenges or eliminating the ability to challenge representation designations as a way to prolong the election process. These are all, and Jim can speak on it better than I can. I mean, these are all tools and parts of the law that have been in place and have been kind of implemented by both sides for decades. And this is really changing the rules of the game in this arena at a fundamental level.
Yeah, just speaking of that and bargaining a lot in the private sector where there's the right to strike, and bargaining in the public sector where there's interest arbitration, and doing that for a lot of years. Certainly been through the strikes numbers of times and working through that. It's all about having a balance at the bargaining table of trying to get a deal worked out. That's what everybody wants. I mean, none of us want the strikes or the other aspects of things. It's kind of a last resort. None of us really want the interest arbitration in the public sector. It's a last resort. But this really changes the balance of power at the bargaining table to almost force you to concede lots of issues that you might not otherwise do it. Now, the other side thinks differently, that it balances things. But boy, doing this for a long time on all the different types of way you do this, this is a huge shift in bargaining leverage and the ability to get a contract done. I'm real concerned about this. John, there was a question about secondary strikes and replacing secondary strike workers. The policy of the law seems to suggest it's going to prohibit replacing anybody who strikes, but I don't know the answer to the specifics, but that seems to be the way that's going. Is that your understanding?
Yeah, and I don't know if the PRO Act addresses every iteration or potential impact of the law, but if we're talking about it, and the board is often governed by kind of a mission statement isn't what it is, but it's probably the most accurate way to describe it. There's definitely a tone and an agenda underlying the decisions. And I think to your point, it would be consistent with the direction that things are headed to prohibit replacement through even secondary strikers. Yes.
We're going to talk just a little bit about some of the other stuff. As of March 8th of 2021, there was a final rule that went into effect. And, we talk about independent contractors and other aspects of that. It's tightening up again as far as that goes. But the two core factors are right to control and the right to profit and initiative over those kind of things. At the end of the day, you step back and say, what's really going on with this? So to the degree you want to have people be independent contractors, these are things you got to focus on in that regards. What difference does it make? It'll make a difference once you get to the point of whether you should have applied benefits or other aspects of things, and that's where it can really roll up for you as a liability. And then some of the other factors that come into play are, you got the core factors, but they'll look at a number of things. And there's a bunch of tests for unemployment comp, others. This is the independent contractor final rule, the amount of skill, the permanence of the relationship, and how integrated is it into production and other aspects of that. Again, it's kind of a sit back reality kind of thing. What's really going on here? Is this really an outside business that we're doing business with? Or are these people doing our work?
I think this is an annual slide that we have. This goes up slightly every year. If you're working with federal contractors, there's a minimum wage that must be paid to all individuals involved in work associated with federal contracts. And this year it has gone up to $10.95 an hour, $7.65 an hour for tipped employees.
And obviously, there's lots of debate about whether we're going to see a $15 minimum wage and that push. And stay tuned. We'll keep people updated as to where that is, but it seems to keep flowing into these other bills, and whether it makes it into the streets and bridges bill, I don't know, but it wouldn't surprise me. We'll see. So earlier I'll just mention this briefly. I talked earlier about these burdens of proof and the difference between the federal law and the state law. And again, Wisconsin's a deferral state, which means we have a big discrimination agency. So in those states that have big agencies, a lot of the discrimination cases get handled by the state, and the state gets paid to do these from the federal government. What we're seeing, though, is a really interesting trend, and I haven't seen it for years, is even if the ERD, the state, investigated a case and resolved it, found no probable cause, we have probably a half a dozen in our Fox Valley office where we got notice that the EEOC, despite what happened at the state level, has decided they're going to look at it and they're going to decide whether or not something else should have been done with it. So keep your files, keep your documents, stay thorough with your current investigations. Years ago, I had a case that got resolved at the state level. The feds picked it up, found probable cause, and we had to go through the whole scenario. And again, it was found to be no discrimination, but just a heads up. And our job with these things is to let you know of trends and other stuff going on. So this is one of them.
Another change from 2020, and this is a direct result of the change in administration, is OSHA seems to have woken up and now wants to participate in the discussion of COVID guidance. I think most of 2020, they were parroting what was coming out of the CDC and the various departments of health, but didn't really have, for the most part, they were just relying on outside sources and weren't implementing their own standards or protocols. And I think in 2020, there were 369 private workplaces inspected for COVID-19 related issues, $4.2 million in fines levied. So it's a small number of employers for a significant amount of money. But based on that 369 employer number, the scope and the initiative was relatively small. It wasn't a primary focus. And OSHA has already come out in early 2021. And so that is going to be different this year. They're committed to, they've promised for more enforcement under the general duty clause. And if you've attended any of the COVID presentations over the last year, where we talked about potential liability and we're seeing a lot of guidance, but where can there be actual consequences for failure to implement reasonable safety precautions? You've heard about this general duty clause under OSHA to provide a safe work environment. There's also the Wisconsin Safe Play statute that it is very similar, but OSHA is now come out and said that they are going to be more proactive in looking at COVID protocols and enforcing and policing unsafe working environments in a COVID perspective under this general duty clause. So what does that mean for employers? It means that in a time period where state approach to COVID precautions is changing all the time, and Wisconsin is no exception. We're going to have a Supreme Court decision, or we had a Supreme Court decision that we're going to talk about in a minute here that overruled the mask mandate. So now there is no statewide mask mandate, certainly plenty of local mandates to keep in mind, but no statewide mask mandate. And that is the trend that's happening across the country. In my humble opinion, I think the federal government's using OSHA as a way to step in and require masks, at least in the workplace. And I think that employers that back off of their COVID protocols, whether it be masking protocols, social distancing, in-person meetings, lunchroom practices, ventilation practices, all of the things that you've seen or heard us talk about over the last year, and the things that you've implemented barriers and changed the way that the office operates, unless that is creating a very significant issue and you need to address it because the function of your business just it needs some tweaking because it's unworkable. If you're tolerating it the recommendation is stay the course with these reasonable safety precautions, because the anticipation, at least what OSHA is indicating, is there's going to be a new wave of enforcement in 2021 for under the general duty clause for employers. And what is going to be the focus of that examination is whether these policies and practices are in place to avoid the spread of COVID-19. And employers that have taken reasonable precautions, it remains to be seen how strict they're going to get, but I'm hopeful that reasonable efforts to address the spread of COVID-19 will be sufficient to avoid significant consequences. I think employers that completely take their foot off the gas and just eliminate any reasonable precautions, I think there's a potential for consequence and for penalties if there's an OSHA inspection. And OSHA inspections can be random, but they're also, in a lot of cases, driven by employee complaints. So you have employees who are uncomfortable with the work environment. OSHA in 2021, it looks like, is going to be much more receptive to those complaints and active on those complaints than OSHA in 2020.
Yeah, John, I think your comment about, in your humble opinion, you think this is what's going on. I think you're dead right in that that's what's going on. And regardless of how we feel about masks and stuff, there's clearly this policy coming through the agency and the enforcements to do it indirectly through OSHA and other aspects. So the precautions that you're talking about are really well stated. As most of you know, the Supreme Court issued at least case number two in regards to the governor's authority in issuing the emergency declarations. You may recall there was a first case we reported on probably around last year, John. I'd have to think of when that one came down, but that one had to do with how extreme they could be about closing businesses. And the court in that case said, no, that was too broad in terms of the ability to close businesses and do that. So, and there are a couple more cases coming we're waiting for on decisions, but this one had to do essentially with the mask declaration. And what happened was, in the way the law works, is the governor gets 60 days to do things. And when one of the 60 days would expire, he'd extend it as a new emergency declaration. So the issue really was, does the governor get 60 days end of discussion, or can the governor, Democrat or Republican, any governor, have the authority to extend or issue a new let me just say that, not extend, but issue a new one and say, well, this is a new emergency, this is a new situation, and I can do that. So that's gone on 3 or 4 times during the pendency of this particular case. And what the court said is, no, you really don't. This is a balance of power between the executive branch, the governor, and the legislative branch. The governor has authority through 2 ways. He can either get it through the Wisconsin Supreme Court. That's not this. This isn't an authority through that. But the legislature had put together some statutes that talked about dealing with emergencies, one of them being a health crisis scenario, which this is. And that's not an issue under the case. And in these situations, the governor gets one 60-day period. And then the idea under the statute, and what the court says is, this is what you guys agreed to. We're just interpreting what you guys put together in your statute. Congress or the legislature the state legislature put this together. The governor signed it way back when. Your deal was governor gets 60 days as an executive to step in. And then you all sit down and put your egos aside and help the people in the state come up with a solution. In the first case that I talked about earlier, they wanted an injunction to keep certain things in place, and the court said, we're not doing your business. You all be big boys and you go back in the room and do your business, sit down and help the people in the state of Wisconsin. Well, in this case as well, the court said, you guys came up with this rule, 60 days, and then you'd all be grown-ups and put your big boy pants on and go do the people's business. Go do the people's business, for God's sakes. Well, here we sit today, and I see the date on that was March 31st, not all that long ago, but I'm not real optimistic. that despite the Supreme Court's polite suggestion that they all go back and do their business, that's really going to happen. So stay tuned on that, but that's the background. It's really not one practical aspect, as John said. No, it's having a practical impact through the other aspects of things. But and then there are these other mandates through the local mandates through the cities and the counties and the other stuff. So we may have them anyway. And as I'm on the Tobago all over the place, all over the state, I'm not seeing a big shift in businesses that aren't still requiring it others. And you definitely have the authority to do it as a business if you want to, or a school district or others. There isn't a constitutional right. There might be a health reason with proper medical verification or religious reason with proper verification, but there are rights to have these policies if you want.
Yeah, I think, and that was the point of this slide, is that absent the statewide directive, now the local departments of health and the local governments are passing their own. This is the list from just the immediate area. They have some minor deviations from their definitions. They certainly have different expiration dates and whether they're going to be renewed or changed. Or, I mean, it's challenging for an employer that's operating in multiple different areas to keep track of what the local requirements are. I think it's with OSHA and certain local governments still requiring masks. I think for all those reasons, our recommendation is certainly to maintain the COVID precautions, at least for the next several months until widespread vaccination occurs. And we see if there's a shift in these directives from departments of health, from the CDC, from the state or federal government, once we have widespread vaccination, what is the tone and temperament regarding these other precautions that we've been living with? Is that going to evolve as well? So I think that's the end. I want to be respectful of everyone's time. We did jump over 2 slides that I think are fairly self-explanatory. The Wisconsin case, Cree versus the LIRC, dealt with arrest and conviction record. An individual had been convicted of very serious crimes against a family member. And the LIRC concluded that the crimes were not substantially related, in large part because it didn't show a propensity for violence against individuals or non-related individuals. So I think it's just a cautionary case, because I believe most employers are surprised at how narrow the substantially related analysis can be and how fact specific it is. I think people look at a rap sheet and just get the gut feeling of violent, bad person, don't really want them around customers, our coworkers, family businesses, whatever the dynamic, they get uneasy. But the LIRC in this case is requiring, and the Court of Appeals, in this case is requiring even a closer examination that specifically ties the offenses to the work environment. And it has to be more than this person appears to, again, be a bad actor. And then the last piece is on civil immunity, and this was passed by the state, I think, in early 2021, but it provides immunity for employers from any damages caused by COVID-19 if they are taking reasonable precautions. I think that immunity does not apply. This is the exception. The immunity does not apply to an act or omission that involves reckless or wanton conduct of intentional misconduct. So again, an employer that's taking reasonable safety precautions is clearly not guilty of wanton conduct or intentional misconduct, and therefore would qualify for the civil liability exemption.
Well, thanks, John. And again, in respect for everybody's time, I think we've covered a broad range, like we do every year, of the trends, the things to look out for, and we'll keep track of things again as the year goes on and keep people updated. Back to you, John Casper.
Great, great program, Jim and John, as always. A lot of information, a lot of things to keep your eye on, and a lot of things to be concerned about in the as this legislation works its way through Congress and other places. So again, next HR briefing is May 20th, 8 o'clock. We'll come to you via Zoom again. hopefully get back to in person, fairly soon here. So we're working on a topic with Jim and John, so we'll be looking for that. We'll be promoting that. This has been recorded, as you all know, and it'll be online probably early this afternoon if you want to take a look at it, and then we'll be pushing it out again to the membership. So with that, thanks to Jim Macy and John Iden with Von Riesen and Roper, and we will see you again next month. Thanks again.
Thank you.
You all.